So pharmacy law can be a really difficult thing to understand, and that's really because there's many elements of law that could apply to pharmacy, which therefore contributes to the intricacies around the regulations. Now, when most people think about the law, they think about a book of rules and regulations. Now, the general view of this metaphorical book of rules and regulations is very authoritative. It sets the guidance of what we can and can't do, and if we go against it, then we will be penalised. However, a view of law in this way is just too narrow. If you think about the regulation of human affairs and human relationships, there's a lot more than to deal with than a set of rules and regulations can actually account for. You'll see that laws have to be adaptable to reflect a variety of circumstances, and they have to cover dynamic changes in human affairs and relationships that weren't necessarily foreseen when the laws actually were drafted in the beginning. Saying that, it's important to know the intricacies of law, what the main divisions are and how they've come about. So the main divisions of law, we've got the first one, statute law, and this is a law that's come about by going through Parliament, and there's three different types. You've got the first one, which is criminal law, largely self-explanatory, and I would assume that most of us are quite familiar with this. It's concerned with the relationship between an individual and the state. So if you consider a criminal, they will be there will be an agency whose task is to prevent and investigate and detect crime, so the police. They will be prosecuting the offenders in a medium, so the courts, and there are methods by which to convict defendants as well, so the punishment, which may be jail. Now, some aspects of criminal law do have a direct bearing on pharmacy practice. So if we consider the requirement of prescription-only medicine, so that's a term that you'll become familiar with in the forthcoming lectures, they can only be sold or supplied in accordance with a prescription given by a prescriber. Now, violation of this requirement amounts to a criminal offence. The second type of statute law is administrative law, and that regulates the activities of public bodies, for example, the NHS. So where the NHS has a contract with community pharmacy, the administrative law will be regulating those activities. And lastly, we've got professional law, and that underpins the powers of professional regulatory bodies. So in the world of pharmacy, that's the General Pharmaceutical Council. The second division of law is civil law, and that's concerned with relationships between individuals and relates to the conduct of human relationships. Civil law recognises individual and collective civil rights, which regulate relationships between individuals, and the law protects and enforces these rights by allowing individual members of society who feel that one of their rights have been infringed to sue the other individual who is believed to have infringed that right. The major difference between criminal law and civil law is that the state takes no active part on behalf of individual members of society in civil law actions. It does have a direct involvement in the development of the laws, which embody the individual civil rights, and it also provides the methods and the system, so the judges and the courts, etc., where individuals can enforce their specific rights. It's important to remember the same set of facts can give rise to both criminal and civil actions. For example, a pharmacist employer who fails to maintain a set of steps which results in an injury to an employee may be sued in the civil court by the employee and prosecuted in the criminal court for failing to ensure the health and safety and welfare of their employees. So where do all these laws come from? So there's four main sources of law. The first one is primary legislation. So each law has a foundation of some kind. In the UK, the rules in the legal system have their foundation in acts performed by Parliament, and they're written down as a matter of public record. They're known as the legislation. Primary legislation is essentially what we know as Acts of Parliament, which are created through a formal procedure. So we talk about Acts of Parliament, but what exactly is Parliament? Well, it's comprised of three main elements. The first one is the House of Commons. That's an elected body of individuals, and the political party with the most seats forms the government. As the name suggests, the role of the government is to govern the country, a role it achieves through a large number of government departments, each headed by a government minister. The government has the greatest influence over lawmaking or legislative process. The House of Lords The members of this House have not been elected. They're either hereditary, which nowadays is very few, or they've been appointed. Now, the role of the peers, which is a term that's used, is to participate in the government and to contribute to the lawmaking work of the Commons. They participate in debates and in committees. And the last element of Parliament is the monarch, so the Queen, and the role of the monarch in lawmaking is now purely ceremonial. The Queen will open up each parliamentary session at the formal state opening of the Parliament. As part of the ceremony, she will make a speech, so that's known as the Queen's Speech, and that details the legislation Parliament intends to enact during the following session. The speech is written by the Prime Minister's office, and the Queen has no control over its content. So how do legislation come about? Now, most pieces of primary legislation begin their life as proposals from cabinet ministers, either on suggestion from government advisors or as a result of a commitment to make new laws in an election manifesto. What can happen is a green paper is published by a government department and it sets out the government's views on an issue and asks for public comment. The next step is a white paper is produced based on the comments from the green paper consultations. The white paper puts forward a firm proposal, but it does leave room for minor changes. If agreement is reached, the proposals are drafted into a document called a bill, and they begin their formal passage through Parliament. Now, in the House of Commons, the bill will go through 5 stages. The first stage, which is the first reading, that's a formality, generally introducing that the bill is there and setting a date for its second reading. Now, the second reading, the minister responsible for the introduction of the bill will formally propose its adoption. Then there'll be a full debate on the merits of the bill and a vote by all MPs present. The third stage, which is the most crucial, the committee stage, is the most important stage. The bill is considered word for word, clause by clause, by a committee of about 25 to 45 MPs. Any significant amendments required can be proposed and adopted at this stage. Then we've got the fourth stage, the report stage. The committee report its finding to the full House of Commons. A debate will take place and further amendments can be suggested and a vote will be taken on the merits of the bill. And the fifth stage, which is the third reading, is generally a short debate. It takes place, but generally only a few significant amendments will be introduced. Now, the passage of a bill through any stage can take a considerable amount of time, or it can be quite rapid. For example, we take the Medicines Bill, which is now known as the Medicines Act 1968. Well, the first reading, that took 5 minutes. So introducing it took 5 minutes. The second reading took 5.5 hours. The committee stage, the most crucial stage, had to take place over 20 meetings on an average of 2.5 hours per meeting. So that was a considerable lengthy process. The reporting stage took about 2.5 hours, and the third reading took 1 minute. So it's very variable as how quick the process is. And then after it's gone through the House of Commons, it has to go through the same 5 stages in the House of Lords. The House of Lords, they can introduce significant amendments, but they can't delay any non-financial bill for more than 1 year. Again, it can take varying amounts of time. So again, considering the Medicines Bill, we've got 1 minute for the first reading, 1.5 hours for the second reading, 2.5 hours for the committee stage. The reporting stage took about 2 hours, and the third reading took, again, 1 minute. Then it has to go to the monarch. Once it's received royal assent, then it can become an Act of Parliament. So the Medicines Bill was given royal assent on the 25th of October 1968, hence why it's called Medicines Act 1968. Now, primary legislation is usually enacted to introduce a new scheme of laws for a particular area. However, primary legislation can be repealed or revoked or amended, and it can replace earlier legislation deemed to be out of date or otherwise in need of reform. The next source of law can be secondary legislation. So most Acts of Parliament delegate powers to other bodies to make detailed rules to complete the whole schedule of the programme of the law, which the minister or proposer intended to introduce. Now, those rules are known as secondary or delegated legislation. The major type of secondary legislation is the statutory instrument. An example in pharmacy related is a statutory instrument is the misuse of drugs regulations in 1985, and that was made by the Home Secretary under certain sections of the Misuse of Drugs Act 1971. Now, a statutory instrument may repeal or amend early statutory instruments, and in turn may be repealed or amended itself. The process of enacting secondary legislation depends on its importance and urgency. The most important secondary legislation will be subject to substantial debate and vote, whilst the least important legislation doesn't need to even be laid before the Parliament at all. Another source of law is judicial precedent. Now, courts and judges have a formal role in formulating laws through this process. It's otherwise known as case law, common law, or judge law. Now, the difference between legislation and case law is that legislation is described as a body of rules which has gone through that process of going through Parliament, whilst the latter, so judicial precedent, is a statement of legal position in a particular case or situation based on decisions of previous courts in similar situations or cases. So something that we see really enacted on the law type dramas. Now, judges, they make law in two main situations, mainly where there's no legislation on a particular issue or where there is legislation and the meaning is unclear. Now, when judges and courts make laws, they do so according to long-standing traditions and principles, and they will cite those, and you will see those, as I said, in those drama-type programmes. But not all laws are continually involved in lawmaking, although all courts are charged with the duty of developing the law, so everyone should be really contributing. The significant decisions which will develop and shape law are made in the higher court. So we've got the Supreme Court, the Court of Appeal, and the High Court. Now, one example in pharmacy where a judge made a law was where there was no legislation on a particular issue. Now, it happened in 1989, and in this case, the Queen's Bench Division of the High Court, they were asked to determine the duty owed by a pharmacist to a patient in relation to the dispensing of medicinal products in response to a prescription. Okay, so we had a prescription. It was written by Dr. Miller for a Mr. Pendergast, who was an asthmatic, and he had a chest infection. So the doctor prescribed 3 Ventolin inhalers, 250 Filocontin tablets, and 21 amoxil capsules. So these were considered and accepted as commonplace combination of drugs for a patient with asthma and a chest infection, which indeed they are clinically, and you will come to realise that through your studies. Now, Mr. Pendergast took the prescription to a pharmacy where the pharmacist dispensed the inhalers and the Filocontin correctly, but instead of amoxil, he dispensed something else, Darunil, a drug that's used for diabetes to reduce sugar content. Now, Mr. Pendergast wasn't a diabetic, and as a result of taking a large dose of Darunil, he suffered permanent brain damage. Now, in the High Court, the pharmacist argued that the word amoxil on the prescription was unclear, and he was capable because of the illegibility to read it as Darunil. However, assuming the handwriting was unclear, the judge was of the opinion that there was sufficient other indicators to alert the pharmacist to something being wrong. So if he'd had his clinical brain switched on, he would have realised that Darunil, which is 5 milligrams, and amoxil was 250 milligrams, so a significant difference in the strength. The dosage of 250 milligrams was normal for amoxil, but high for Darunil. And also the patient paid for his medications, which he wouldn't have done if he'd been a diabetic. So there were some key things that the pharmacist didn't pick up on. As such, it was concluded that the pharmacist hadn't paid sufficient care, and as a result, fell below the standard of care and skill expected of a pharmacist and had been negligent. With respect to the doctor, the judge made it clear that the doctor did have a duty to his patient to write a prescription clearly and sufficiently legibly to allow for possible mistakes by a busy pharmacist. Having already established that amoxil could in this case have been read as Darunil, the doctor had also been in breach of his duty of care and had been negligent. But the judge concluded that the doctor's negligence had contributed to the pharmacist's negligence, but the greater proportion of the responsibility lay with the pharmacist. As a result, damages of £120,000 were awarded, 75% against the pharmacist and 25% against the doctor. The decision was upheld by the Court of Appeal. So there's a clear example there of where a judge has made a decision despite the fact that no legislation was actually in force. Now, the last source of law is the European Union law. Now, I'm not going to go into the depths of this at the moment because we are, as I give this voiceover, we have just left the European Union. So how much of this will be relevant is yet to be seen, really. I'll just give you a bit of the background. So the UK joined the EU in 1973, and after that point, almost all law relevant to medicine was actually derived by the EU. Therefore, Europe has been the highest legal authority for such laws in the UK. As I said, I won't be giving you any further information about that. We'll just see what happens in the next few months and how it impacts pharmacy law. So I hope from this you've seen the general process of lawmaking. We've also looked at some of the terminology associated with the law. We've also seen two major divisions of law and how they have an effect on pharmacy practice. In addition to the legal influences on pharmacy, it must be remembered that in line with all other professions, pharmacy has professional standards that must be maintained. And that comes from that professional law that I mentioned from the General Pharmaceutical Council. And failure to observe these